and Justice at the Center for Democratic Development, CDD, Professor Asare, has argued that Article 8, Clause 2 and 94(2)(a) of the 1992 Constitution have been misinterpreted for years as far as the application of the law on dual citizenship and also allegiance are concerned. He explained that there are fundamental differences between the two articles. So here's what we're going to do for you, our viewers, to have a clear understanding of the clear fundamental differences. We'll hear from him, but this is what Article 8(2) of the 1992 Constitution states. Let's put it on the screen right now. And this is it. Without prejudice to Article 94(2)(a) of the 1992 Constitution, no citizen of Ghana shall qualify to be appointed as a holder of any office specified in this clause if he holds the citizenship of any other country in addition to his citizenship of Ghana. And this is what 94(2)(a) says. 94(2)(a) says a person shall not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana. So this 94(2)(a) is specific about a particular role, that's member of parliament. But 8(2) gives also some further detail. Now, as to exactly what these offices are, is what Professor Asare is making the argument. Now, let's take a look at the Citizenship Act. Now, this Citizenship Act 2000, Act 591, Section 16(2) says, and I quote, without prejudice to Article 94(2)(a) of the Constitution, no citizen of Ghana shall qualify to be appointed as a holder of any of the offices specified in this subsection if he holds the position in the following. And so this Citizenship Act gives some further detail of the specific offices that persons who hold the citizenship of any other country in addition to citizenship of Ghana cannot be appointed to. Let's take a look at the offices. And if a member of parliament is mentioned there, you have Inspector General of Police, Commissioner, Customs, Excise and Preventive Service, Director of Immigration Service, Commissioner, Value Added Tax, let's go on, Chief Justice of, and then Justices of the Supreme Court, Ambassador or High Commissioner, Secretary to the Cabinet, Chief of Defense Staff or any service chief. So these are the detail, and it follows like that. The Director of Immigration Service, and then it goes on to talk about the Director General Prison Service, Chief Fire Officer, Chief Director of a ministry, the rank of a colonel in the army or its equivalent in other security services. So there's some detail that the Citizenship Act gives about that specific office that 94(2) talks about. So that's what I sought to find out from Professor Asare. And remember, this particular, the Citizenship Act, there is a bill in Parliament that seeks to amend this Citizenship Act. And from the last time we checked, the bill is awaiting second and third reading in Parliament. And it has already received the blessing of the Council of State as well on this. Professor Asare, Stephen Asare, is a University of Florida lecturer in law. He's also a member of the Florida Bar. He's a CDD Fellow, Public Law and Justice. I asked him whether the justification for this Citizenship Act in its current form may have outlived its usefulness. This is what he had to say.
To remember that the assembly, the committee of experts and the consultative assembly that discussed the 1992 Constitution and ultimately promulgated it, discussed this question. And their solution in 1992 was that dual citizenship was not allowed. Dual citizenship was not allowed. So the Article 8(2) that you are reading is an amendment. I call it the first amendment. It was procured in 1996. I was part of the lobby that actually got the amendment. And the reasons we gave and the reasons Parliament saw eye to eye with us was because dual citizenship itself had become an unexceptional status. Or initially, historically, people or countries were a little suspicious of people who had other citizenships. Not because they didn't want them to hold office, but because they wanted to control these people in times of war. The British were notorious for doing that because many of their citizens, in those days, they actually called them subjects. Many of their subjects would migrate to North America, and if there was a war, the British doctrine was that their subjects owed permanent and perpetual allegiance to them. So even if they had taken on the citizenship of another country, such as America, they could conscript them and use them in war. Now, we don't fight wars anymore, and most countries have shared these archaic views about dual citizenship. And so in 1996, when we went to Parliament, Parliament understood what we were saying, and Parliament said, yes, it's time to repeal the old Article 8 that outlawed dual citizenship, and then inserted the new Article 8.1, which says a citizen of Ghana can hold the citizenship of another country. And Alfred, the reason that is important is that it tells us that Article 94.2a, which is on allegiance, has nothing to do with dual citizenship, because Article 94.2a was in the Constitution at a time when dual citizenship was not even allowed. Unfortunately, there is some minimalist interpretation of the Constitution which goes like that. When we see allegiance, because allegiance has something to do with citizenship, then allegiance, as used in Article 94.2, has something to do with citizenship. It doesn't, absolutely. That is a minimalist interpretation of the Constitution that ignores the history behind the use of allegiance in Article 94.2a. And if you go to countries like Sierra Leone, Nigeria, Australia, and all the Commonwealth countries, there is a strong distinction between allegiance to a country and citizenship of a country. This is a British inheritance. We inherited that allegiance to a country other than Ghana from the British, and it is a feudal idea. In fact, if you look at the first Republic Constitution, which was controlled and written by Nkrumah, who had a very keen awareness of colonialism and feudalism, the old allegiance to a country other than Ghana is entirely expunged from the 1960 Constitution. You can see it in the 1957 Constitution that was under the monarchy. Then they copied it back in the 1969 Constitution, the 1979 Constitution, the 1992 Constitution, but it has nothing to do with citizenship. If you go and you read the 1969 proposals on promulgating the Constitution, it is occupation related. It is directed against people who are in occupations that are incompatible with being an MP, right? So an example of that would be someone who served in the military of a foreign country that was an enemy of Ghana, or somebody who was a Ghanaian, a single citizen Ghanaian, because remember, dual citizenship is not even allowed. A single citizen who spied for another country. Some of you may recall the swap between Susudis and 8 single citizen Ghanaians. That allegiance to a country other than Ghana is referring to that, not dual citizenship. Nevertheless, our courts, I mean, obviously, the high courts, and it appears now the Supreme Court, although we don't have their reasoning, for whatever reason, strange. The Supreme Court is also equating allegiance to citizenship, a very fundamental mistake. Nevertheless, look, we have evolved in our thinking about citizenship. If you go back and you read citizenship, you read about citizenship, you go to the ancient Greece, they thought citizenship should be confined only to property owners. Then you go to the Roman Empire, they thought citizenship should be confined to the residents of Rome, and others that they conquered are not citizens, they are aliens. Then if you go to the British Empire, borrowing from feudal law, they conceptualize citizens as subjects who owed allegiance to the monarch, who owed perpetual allegiance to the monarch. All of these views about citizenship, if people read the literature on citizenship, are archaic. Today, in just about every country, including in our own constitution, if you study our constitution carefully, citizenship is viewed as a bundle of rights and some reciprocal duties to the state. What distinguishes a Ghanaian citizen from a non-Ghanaian citizen is the right to participate equally and fully in the political space. That's why yesterday I posted a clip from the Sierra Leone Supreme Court, which basically is to the effect, you cannot say you have a citizen, but that citizen does not have political rights.
Right.
The most important political right is the right to vote and the right to be voted for.
Right.
So in Sierra Leone, in Nigeria, in most countries, all citizens have the right to be voted for. Now, this is not to say you are compelled to vote for somebody who is a dual citizen, but if somebody is a dual citizen, he should be given the right to make his case. Right. And if the people want him, let them vote for him. That's why I support this bill that is in Parliament. That is why I'm happy that there is a bipartisan agreement around it. There's consensus. The Council of State, in its wisdom, has seen that, look, we have to treat all Ghanaians equally.
That's right.
And so I'm happy that this bill is going through, and I hope it is passed this June when Parliament reconvenes.
What is the problem with the interpretation of 94.2 when it comes to people seeking to be MPs, in this case of James Jachikwason, and how this development would impact on the people, the diaspora coming in to help develop this country? Prof.
Well, clearly the Jachikwason case has nothing to do with Article 94.2, because as I said, he is not even a dual citizen. He has renounced his citizenship. And the issue is, when did he renounce his citizenship? The law, the current law in PNDC law 284, section 9, 2, says that in order to be eligible for Parliament, the test of allegiance is determined at the time of the election, not at the time of filing your nomination. That notion that at the time of filing your nomination, you should be a single citizen is wrong as a matter of law. I mean, anybody at all can go and read the PNDC law. And when you read the PNDC law, it is crystal clear that Jachikwason qualified to run for MP. And in fact, the Electoral Commission itself is the one that wrote those regulations. They said he qualified. The Supreme Court is now coming in and is saying, well, we don't like what PNDC law 284 is saying about the timing of allegiance. Therefore, we are going to set our own time. And not only are we going to set our own time, we are going to apply it retrospectively to disqualify this person from Parliament. That is politics. That has